her as what's called a litigation guardian. And because you're the treatment person working with her and she's got great confidence in you, she starts asking you questions. But what does this mean? I don't understand this. What should I be doing? So, what we want to do tonight is talk a little bit about who can be a litigation guardian, what the role is of the litigation guardian, and the responsibilities of that person. And before we start down that road, as a lawyer, it's our responsibility to present legal options to our clients. We make recommendations, we accept their instructions on how the action is to proceed. But the fundamental principle in any lawsuit is that the client remains in control of their proceeding. Right? It's not up to me, it's not up to Adam. The client's the one that runs the show. But there are going to be certain circumstances where the clients just aren't capable of providing us with the instructions and they can't control their own action. And in that case, that's where we're talking about the litigation guardian. So a litigation guardian is somebody who's going to be appointed to represent a person under disability, it's their formal name, during the lawsuit. And the litigation's job is to give us, as the lawyers, the instructions with respect to the day-to-day decision making that's going to be required throughout the course of the litigation. And as well, if we can get the case to settlement, then they're also going to be responsible for giving us instructions with respect to resolution. And the starting point for being a litigation guardian is under Rule 7 of the Rules of Civil Procedure. And that's which requires someone who is under disability to be represented by a litigation guardian. So Adam, if you can come back on screen and maybe tell us just exactly who is a person under disability.
Great, thanks, Stacy. So a person under disability has two definitions in the Rules of Civil Procedure. The first is a little more straightforward. It's a person who's under 18 years of age, or what we will call a minor. The second is a person who is considered mentally incapable under the law. And the definition of mentally incapable is something that's going to be canvassed in future webinars, so we're not going to dwell on it too much here. But for example, in our case study, Raymond, the person who his mother Janet has brought to you, is under 18 years of age. So therefore, he's automatically considered a person under disability in the law. If, for example, Raymond suffered a brain injury during the accident that he was involved in, and as a result of that brain injury, he met the test for someone who is mentally incapable under the law, he would require a litigation guardian regardless of whether he was over or under 18 years of age. Usually, the determination that someone is mentally incapable under the law is made by a capacity assessor, who's a professional in their own right. And that usually involves the person who is suspected that they may be mentally incapable meeting with the capacity assessor, and the capacity assessor usually does their assessment. They ask questions, they take notes, they might review relevant medical history, and they usually generate a report that has their opinion about what this person is capable of doing. That report usually informs the lawyer about whether or not a litigation guardian is required, or whether the person is capable of directing the litigation in a way that there is no need for a litigation guardian. Moving forward, let's talk about who can be appointed a litigation guardian. So the Rules of Civil Procedure have 4 requirements for someone who can be a litigation guardian. The first is they must be at least 18 years of age. The second, they must be a resident of Ontario. Third, they must be willing to act as a litigation guardian. And the last one is that they must not have any adverse interest to the person under disability. And what that means is that there's no potential that the litigation guardian could be found to be responsible for the person under disability's injuries. And I can give you an example of that. So in our case, Janet, who's Raymond's mother, is asked to be litigation guardian, and Raymond was injured in a motor vehicle accident. If Janet was the person driving the motor vehicle at the time, it may not be a good idea to name her litigation guardian, because if it comes out that Janet's actions when driving the motor vehicle were in some way responsible for the accident, then Janet could be considered adverse in interest because in the lawsuit, it would be in her interest to say, I was not responsible for these injuries. And we may need to prove that she is responsible for those injuries in order to get funding for Raymond. In a different example, if someone is the owner of a house and a person is injured in a slip and fall on their property, usually the owner of the house, who in law would typically be considered someone who could be liable for the person who fell's injuries, that homeowner wouldn't be a good decision to act as litigation guardian, again because there's that possibility that they may be considered a party that's adverse in interest. So there's no requirement for a litigation guardian to be the person under disability's family member. However, what we find in most cases is that this is the case because a family member typically knows the person well, they have a good relationship, they have an understanding of their limitations and their needs, and they're often willing to act. And I'll just take you back there for a second to that third requirement for a litigation guardian, which is the willingness to act as the litigation guardian. That's important because, as we're going to tell you later in this presentation, being a litigation guardian requires a lot of responsibility and it does put you at risk for paying the cost of the litigation if you go to trial and you lose. So, that willing part, while most people would think that it's automatic, it's not always the case. So in our case, Janet, who's Raymond's mother, assuming she wasn't driving the motor vehicle, would probably be a good candidate to have as a litigation guardian. Now, there could be a friend of Raymond's, provided they're over 18 and willing, who could act as litigation guardian. If nobody, a family member, friend, acquaintance is willing to act as litigation guardian, there is the option to hire a lawyer to act as litigation guardian. This lawyer would be someone who is separate and apart from the lawyers who are representing Raymond. So, for example, we're the lawyers who are representing Raymond. If we were to hire a lawyer as a litigation guardian, it wouldn't be someone from our firm typically. Or as a last resort, there are government offices that exist to act as the litigation guardian. So, if the person under disability is a minor, the Office of the Children's Lawyer can act as litigation guardian if no one is willing or qualified to act. If the person under disability is a person who's suffering from a mental incapacity, the Office of the Public Guardian and Trustee can act as the litigation guardian. If the person under disability is both a minor and suffering from a mental incapacity, either the Office of the Children's Lawyer or the Public Guardian and Trustee, can act as litigation guardian. Now, while it seems attractive that there are government offices that are able to act as someone's litigation guardian, there's other practical considerations that you have to think about before deciding that you want the government office to act. Those considerations are, as Stacy said, a litigation guardian's responsibility for giving instructions in the lawsuit can take a bit longer when you have a government office that responds to those instructions. A litigation guardian, for example, who's a family member, might be able to respond quicker, to interact with the person under disability on a daily basis, and have a more timely and informed view of what that person needs and what might be in their best interest in the litigation. Just something to consider. Now, moving forward to the next topic, how does one become a litigation guardian? So in our case, if Janet wants to be a litigation guardian, she'll have to swear an oath or affirmation and sign a document called an affidavit of litigation guardian, stating she wishes to act as Raymond's litigation guardian. This affidavit will contain the following information: a statement that Janet consents to act as Raymond's litigation guardian, a statement that Janet has given written authority to act for Raymond to a lawyer. That's another requirement. A litigation guardian can't represent a person on their own. If you're appointed litigation guardian, you will need to retain a lawyer to act for the person under disability. The affidavit also requires information about the person under disability's disability. In Raymond's case, because he's a minor, it would simply be a statement that Raymond's a minor and they would give Raymond's date of birth. If the person under disability is suffering from a mental incapacity, that information might be a statement detailing a little bit about their injuries, detailing their cognitive capacity, detailing any psychological issues they might be dealing with. It doesn't have to be long or detailed, but it does have to give the court an idea of why this person is a person under disability. It will also require a statement that the litigation guardian and the person under disability ordinarily reside in Ontario. You will need information about the person under disability and the litigation guardian's relationship. In our case study, a statement that Janet is Raymond's mother would often be enough. Again, it's not an onerous hurdle to pass over to get the information for this affidavit. Then there will need to be a statement that the litigation guardian has no adverse interest to the person under disability. And again, but we just talked about that before, but that just means that it's not likely that they're going to be found responsible for that person's injuries. And lastly, a statement acknowledging that the litigation guardian has been informed that they're liable to pay any costs awarded against the person under disability in their case. So at this point, I just want to briefly explain what we mean when we say costs and being liable to pay costs. So in Ontario, generally the loser pays the winner's costs of litigation. And the cost of litigation can be things like legal fees for lawyers. It can be disbursements that a law firm might pay out of their pocket to move the case forward. Disbursements include things like filing fees, paying treatment professionals, things like that. And if you go to trial and you lose, typically you pay for the other side's legal fees and disbursements. As the litigation guardian, and by signing that litigation guardian affidavit, the litigation guardian is saying, if we go to trial and the person under disability loses their case, I am liable to pay those costs. Now, before anyone gets too afraid, going to trial is very rare in most cases. Most cases settle before they go to trial. And at least in our case, we're reminding the litigation guardian and all our clients constantly before trial about certain points in the litigation, about the risk of going to trial, and thinking of other solutions such as settling the case or possibly discontinuing. So it's an important thing to think about before becoming a litigation guardian. But in our opinion, typically the risk is not great that you're going to be paying costs at trial. Or at least if there is a risk, we're going to give you a heads up well ahead of time. Before I turn it over to Stacy, I do want to say one more thing as well. We're going to be talking a lot about affidavits in this presentation. I just want to give you a brief understanding about what an affidavit is. It's just a document that you take and it tells your side of the story, or it gives information coming from you. When you do something called swearing an affidavit, what usually happens is you're in the presence of someone who's a commissioner, usually a lawyer, and you read the affidavit, and in front of the commissioner, you swear it to be true and you sign it. And then the commissioner signs it to say that they witnessed it. Now, in the COVID age, it can be daunting or difficult to meet in person to do these affidavits. It is possible to do them online and do them over Zoom. So just wanted everyone to know that that is an option and it's not something that's slowing litigation on our part. So I'm going to turn it over to Stacy now to talk about the litigation guardian's role in the case.
Thank you, Adam. So the litigation guardian takes a bit of an active role in the litigation. First and foremost, the litigation guardian is the person that generally hires the lawyer to represent the party under disability. So the litigation guardian is responsible for signing the retainer agreement, which is the contract of services, sets out how the law firm is going to get paid. The litigation guardian is then responsible for making all of the day-to-day decisions in moving the case forward. They are responsible for providing us with all of the information that we are going to need: names of doctors, health card, social insurance number, school records, all of the information. They basically become our contact person, and they also become the contact person for most of the treatment providers as well. And this is especially so when we're talking about somebody who has a family member who's looking after things for them. At some point, after the action has been started by issuing and delivering a statement of claim, the next step is the insurance company hires a lawyer. They deliver a statement of defense. After that, the next major step is what's called examinations for discovery. And in the normal course, the plaintiff, that's the injured party, participates in an examination for discovery. That's where we go together to a court reporter's office, or like we're doing these days, over a Zoom call. And the lawyer for the other side gets to ask all kinds of questions. Everything from name, age, date of birth, education, employment history, how the accident happened, injuries, how it's affected them. But when we're dealing with somebody who has a litigation guardian who is representing them, it's a little bit different. So if we're talking about a minor who is under the age of 12, most times you're going to have the litigation guardian who's going to have to attend and give the evidence under oath on their behalf. If the child is age 12 or older, and it also does depend on the extent or the complexity of their injuries, they may be required to testify at the examination for discovery themselves. And that it's also can be quite scary, but like I said, you've got, you do have the lawyer with you, or the client will have their lawyer with them at all times. And it's not like the lawyers on the other side get to berate them or yell at them or do what we see on TV. It's actually quite a civil process. If we're talking about an adult who has a severe brain injury, again, it really does just depend on the complexity of their injuries, as to whether or not that person testifies or whether the litigation guardian testifies on their behalf. And sometimes it's just purely a strategic decision as well. Like I've had cases where, our client has been quite brain injured and we wanted them to be presented for examination for discovery, even though it was a very short one. We're giving the other side, the insurance company's lawyer, the opportunity to meet our client, put a face to the name that they see on paper. And it also just gives them an opportunity to really get some insight into the challenges that our client is facing. And I know in the past, I've been questioned on this, right? Whether it's been by the litigation guardian, parents, even treatment providers are like, are you sure? Or, is it right that this person is being compelled to come to an examination for discovery? And it does really all depend on the circumstances. But from my point of view, from a practice perspective, if I can put my client in front of the other lawyer, so that person is able to really get a good understanding of what the injuries and the impairments are, then sometimes that's what takes priority over, I don't want to say whether it's the right thing to do or not, because I would never put my clients in a position to force them to go to a discovery if I thought that it wasn't going to be good for their health, if it wasn't going to help their case, if it wasn't going to, sort of bring any sort of harm onto them in any way, then obviously that's not something that we would do. But it is, like I said, it is part of the strategic process, especially when we're dealing with insurance companies. When the claim settles, the litigation guardian is responsible for swearing an affidavit to the court that they have confirmed their instructions to settle. And that in itself is a little different than what we see in a normal action where we don't have somebody who has a litigation guardian. If you have a litigation guardian, the court gets the final say in whether or not the claim can be settled. So that means if I think, Raymond's case is worth, $2 or $3 million, and the other side, that's what they want to pay, and the litigation guardian says, yep, we agree, we think this is what it's worth, doesn't matter. At the end of the day, it's up to the court to make the final decision as to whether or not that's a reasonable settlement. And so it is the job of the lawyers, it would be our job to convince the court as to why we think that's the right thing to do. But the litigation guardian will play a big role in that process because they're the ones who are going to, recite what happened, talk about the development of the injuries, talk about how the treatment has gone on for all of these years, and, sort of give their reasons as to why they've agreed to follow our recommendation to accept this settlement. Once the court accepts that, if they agree that it's a good settlement, the action is over. At that point, um, the role of the litigation guardian ends. And in a second, Adam's going to talk about how that happens. Um, but before we move on to that, there's two things to keep in mind is that in the normal course, the litigation guardian doesn't manage the financial affairs of the person under disability. Unless, of course, it's their child. That's a completely different circumstance. But if it was, for example, myself and I was the litigation guardian for, let's say, Adam, it wouldn't be my responsibility to make sure that he pays his bills and that all of his financial obligations gets met. That's a different role. That's a guardian of property. And that's somebody who's appointed by the court under a separate process, usually one that either happens during the course of the litigation or at the end of litigation. The other thing is that the litigation guardian isn't the person who will always be looked at to make the decisions for personal care. So in that same example, it's not up to me as the litigation guardian to determine, whether or not it's appropriate that Adam should be getting a certain level of treatment. Um, obviously if he has parents or if there's someone else in the situation who can help them through with that, but that's certainly not my primary role as the litigation guardian. Adam?
Great. So, like Stacy said, I'm going to talk about how a litigation guardian's role ends. And there's two general ways that the role can end. The first is that the person ceases to be what we would call a person under disability. And the second is when the case itself ends. So I'm going to speak first about when a person is considered to be no longer a person under disability. So if the person under disability is a minor, they will automatically cease to be a person under disability when they turn 18 years of age. Now, depending on the nature of that minor's injuries, it may be necessary, nonetheless, to have them undergo a capacity assessment just before their 18th birthday to see if there is an applicable mental incapacity that would keep them as a person under disability. So let's use our example of Raymond. Raymond's now about to turn 18, and however, the injuries that he suffered in the accident make you as the treatment provider wonder whether Raymond will be able to meet that test for someone who's capable. And again, that test is going to be covered in a later webinar. But let's just say for the purposes of this example that you're not sure and you think maybe he might not meet this test. He might be a person who is considered mentally incapable. At that point, it might be a good idea to raise that with his lawyers. And at that point, he'd probably undergo a capacity assessment. And if the capacity assessment says Raymond has capacity, then great. He turns 18 and he's considered mentally capable. And so he's no longer a person under disability. If the test says that he is in fact considered mentally incapable, even though he turns 18 and he's no longer a person under disability because he's no longer a minor, because he's considered mentally incapable, he remains a person under disability. Now, at this point, usually when a minor turns 18 years of age, they just swear their own affidavit stating that they've reached the age of majority, and we make what's called a motion to the court, and the court discharges the litigation guardian. So minor is now 18, they're no longer a person under disability, the litigation guardian's duties are over. Further, if you're a person under disability and you are deemed to be capable or mentally capable, then you also will have your litigation guardian discharged. So let's use a different example. Let's say Raymond was, at 18 years of age, considered mentally incapable, and so he remained a person under disability. Now Raymond's 25, and his treatment's been working, and he's made some improvements, and you as his treatment provider think that he might be considered capable. Now Raymond goes to a capacity assessor, and that capacity assessor does their assessment, and they make the opinion that Raymond is now in fact capable. At this point, Raymond will swear an affidavit and will make a motion to the court, and his litigation guardian will also be discharged. So that kind of covers our first little area of how a litigation guardian's role ends. At that point, when the person is no longer considered a person under disability. The other way that a litigation guardian's role can end is at the end of the litigation itself. So To put it colloquially, you're along for the whole ride if you're a litigation guardian. Here's some ways that litigation can end. The case can be discontinued. If the case is discontinued, it's usually a decision by the lawyers that if we go to trial, we're very likely to lose. And rather than have the litigation guardian and the person under disability be liable for costs, it's better just to discontinue the litigation. And usually, when that happens, the other side will either give you a break or not require you to pay their costs. If the litigation is going to be discontinued and there's a person under disability, we will need to make a motion to the court in the same way we would do as Stacy was describing for a settlement. In this case, the litigation guardian will need to swear an affidavit and explain to the court why the case is being discontinued. And the lawyer will usually swear an affidavit as well. And the judge or the court will decide whether or not it's in the person under disability's best interest to discontinue the litigation. And if they do decide to discontinue the litigation, if you get that court approval, then as the litigation guardian, your role is over. Stacy talked to you a bit about settlement, and I'm just going to cover as well trial. If you go to trial and you win or lose, your role as a litigation guardian is also over. You're on till the end of the ride. However, this leaves the question, and Stacy touched on this a bit, and I just want to touch on it a bit as well, about what will happen once the litigation guardian's role is over. Typically, if the person is still considered mentally incapable or a minor, the general rule is that any funds that you get will be paid into court. So if you settle or you go to trial and you win, and the person under disability is awarded some money for their injuries, that will get paid into court. One way that the courts are willing to pay out if there is a person under disability is if they have a guardian of property. And a guardian of property, like Stacy said earlier, is not the litigation guardian, so they're not managing the litigation. The guardian of property is managing the person under disability's financial affairs. Typically, when we do settlements involving a person under disability, we do something called a structured settlement. And a structured settlement involves usually another company. We use McKellar's, but something called an annuity is purchased, which is an investment vehicle, and an annuity pays out periodic payments. So the person under disability, for example, might be paid out a certain sum of money every month. There's many benefits to that, one of which is that the payments are tax-free, and courts like it because rather than give the person under disability a large sum of money at the end of the litigation, they have payments that will continue usually throughout the person's lifetime. So the court knows that this person will continue to be provided for. It's something to think about when you are a litigation guardian and your lawyers approach you to settle the case. It might be good at that time to raise the idea of whether a structured settlement will be the person under disability's best interest. So that brings me now to the conclusion. Hopefully from this, you've had an idea about how capacity works from hospital to settlement. And we brought you a little bit further to trial as well. This talk was really about litigation guardians because the litigation guardian for a person who is considered incapable is the person who's driving the litigation. Hopefully you yourself as a treatment provider learned a bit about when it would be a good idea to seek a litigation guardian, how to inform people who are curious about being a litigation guardian, about what that role entails, and also the importance of interacting with a litigation guardian and keeping a litigation guardian informed throughout the litigation, because this is the person who's going to make decisions on behalf of the person under disability. Also, for the healthcare providers, it kind of shows that there's a need to continually assess incapacity. Incapacity is not something that is stagnant, it's dynamic and it changes. A person under disability may be a person under disability one day and they may improve. Conversely, someone who is not considered a person under disability may regress in their condition or their injuries may worsen and they may become a person under disability. And regardless of when someone becomes a person under disability, they will need a litigation guardian. So even if you've gone all the way through your case and it's the day before trial, if that person became a person under disability on that day, they would need a litigation guardian. So as a healthcare provider or a loved one of someone with a brain injury, it's important to keep an eye out for when their status might change and when you might need to bring that up. So I hope that you guys had some benefit from this, and I hope you understand a little bit more about how to manage capacity issues from hospital to settlement and beyond.
Adam, I have a question. So we've talked a lot about litigation guardians for minors, people under the age of 18. Does the minor's opinion ever matter?
Yes. So if you are going to settle a case and there is a minor who is considered the person under disability, if the minor is over 16 years of age, their consent to the settlement is also required. So you have the litigation guardian affidavit, the lawyer's affidavit, and also the minor's affidavit. Stacy, I was wondering something. Can a litigation guardian change in the middle of litigation?
Yes, it can. And we've had to from time to time. Um, Recently, we've had one where the litigation guardian died, sadly, and we had to appoint a new litigation guardian partway through. So just because you have someone who starts out as a litigation guardian in the beginning doesn't necessarily always mean that that's going to be the same person who ends up giving the instructions um, in the end. Does anybody in the audience have any questions? No. Awesome. Okay.
Well, yeah, thank you both to Adam and Stacy. This was very informative, and just to say that we record these sessions, and so it will be available online, and we will also send everyone who participated that document on litigation, so you can have even more information. Yeah, unless we'll just anyone has any questions they can think of now, maybe we'll call it a night.
Okay.
All right. Thank you so much.
Awesome. Thanks everybody for joining us tonight. Much appreciated.
Thank you, everyone. Take care.